this is a situation I've seen quite a few times. I'm sure it's pretty common where you've got domestic abuse involved in a couple where they're both joint tenants, and one party leaves, so flees, moves into temporary accommodation, but they're still still legally liable for the rent, I guess. I mean, a good kind of question additional to this would be, what does jointly and severally liable mean? Because that's a question I think I see a lot. But
Yeah.
what can that victim do about the fact that they're still technically liable? And often you have situations where the perpetrator will deliberately run up rent arrears so that it can then kind of cause further problems for the victim. So what are the options there?
Well, one of the biggest surprises I got in my legal career was when I discovered about the case of, I think it's called Hammersmith v. Monk from about 1992, which is authority for the rule that if there's a joint tenancy, either of the joint tenants, or if there's more than one joint tenant, can terminate the whole thing on behalf of the others without the others' permission or consent. So if you're in an abusive relationship, you can terminate the tenancy and the other one has got no tenancy left and can't run up rent arrears. The problem is that you also haven't got anywhere to live as a result of that. But what I tended to find a lot was that with local authorities, they could come to an agreement with a victim of domestic abuse that they would accept a surrender, which we were talking about, where they terminate the tenancy on behalf of both. So that eliminates the tenancy, and then they grant a discretionary sole tenancy to the victim. And I'm not sure, I've got to look into this, because there was this Domestic Abuse Act, which I have not studied. And there was Doughty Street Chambers had a whole day of lectures on it, and I was too busy. I did sign up for it, but I didn't go. But I'm waiting for the videos. And I'm thinking that there must be something in legislation now to mean that you can require, local authorities are under more of a duty, because it was always whether you were on the right side of a housing officer. And if they wanted to be difficult, they could say, we're not interested. But I think nowadays it would be difficult for them to do that.
So I mean, I think this case would have been around, I think, about 2018 as well. So again, when the HRA was just coming in, basically, victim of domestic abuse went in to a council, and the council officer, literally the first thing they said to her, and they recorded it in their notes, which was amazing in one sense. They said, if you're subject to considerable domestic abuse. If you leave the tenancy, you'll be making yourself intentionally homeless. And when I kind of came across it a few months later, we got a subject access request. We got a copy of these notes. It was the most straightforward compensation claim ever, because clearly, you're not making yourself intentionally homeless if you are subject to domestic abuse by leaving a property or by serving notice on a property. But again, I think in the real world, it's probably something that you'd hope you'd approach the local authority in that situation. You'd come across a good housing officer who talks you through that process and assures you that you're not going to make yourself intentionally homeless by taking that kind of action. So, but yeah, that's something I never knew, that essentially a joint tenant can end the tenancy for both parties. I've certainly seen it implied that actually they're kind of stuck with it, so that's good to know. So,
no, they're not. Because to answer your question of what does joint and several liability means, in a nutshell, it means that the law regards joint people as one person. So something done by one of them on behalf of the others is enough. And it's the same way that if you're in a joint tenancy and you go away and you find that your partner who stayed there or the other joint tenant's been running up rent arrears, the council can come after you for all the rent arrears that they run up because you're jointly liable for them. I'm going to have to study. I'll let you know when I've done my study about the domestic abuse stuff, because I think there must be a lot more. Because I've got one at the moment where somebody's in a joint tenancy, and I've been writing to Lambeth saying, what's she going to do about it? And I'm sure that I should be being more aggressive with them, because normally I'm sort of saying, please, could you do this?
Yeah, I don't think that. So I've read the relevant bits of the Domestic Abuse Act. Obviously, a lot of it concerns things which aren't related to homelessness. But in one sense, it doesn't change the way the law should work, in terms of, you're still homeless through domestic abuse if it's probable that the abuse will continue, or the risk of abuse will continue. And in one sense, because it changed the kind of the automatic priority need characteristic, that meant that it should be much simpler. But in kind of, I don't really see that it changed much else other than that, really. Like there always should have been a duty on councils to act in that situation and to offer safe accommodation. So I don't, I mean, the guidance is very good, incidentally. So the domestic abuse guidance framework is the first place I've seen it written down by a government in a government document about the connection between trauma and substance use or alcohol use in that sense. So it's worth reading, but I don't think that it changed much other than kind of like just making it even clearer than it already was that councils have to
Does it
act.
put any duties on councils to sort of draw up policies for dealing with domestic abuse?
Well, so since 20, so this is interesting. So I've done a lot of work around this in Bedford. So in the 2012, there was this supplementary guidance which said that all councils have to have robust domestic abuse policies,
Ah, there
and
we
it's
go.
something that we've continually raised with Bedford. They still haven't got one. Like I remember raising it back in 2016, 2017. And the council basically said, "Oh, well, we just used the code of guidance." And my colleague John recently worked on a case where they sent a victim of domestic abuse back to the perpetrator when they were then further abused. So I know John's running with that kind of saying, well, you're obviously not using the domestic abuse, you're not using the homelessness code of guidance because you're still seeing these kind of failures. So, but I think legally the law has been pretty good for a while. It's just down to the housing officer whether they like you or not, or whatever the considerations are. Whether they see domestic abuse as a real thing. That case I mentioned before about the advice that if they left the property, they'd be making themselves intentionally homeless. Essentially, in
Yeah.
that process, they would kind of said, well, he's not actually hit you though, has he? So, and there was that kind of like
Oh
complete kind
dear.
of sort of departure from the definition itself. So yeah,
Yeah. I'll look into that, because I think that one of the good things about these robust policies that people are supposed to have is that once they get their act together, somebody commissions a consultant to come in and write something sort of euphoric about how passionate they are about this, and they create all sorts of obligations on themselves. And then if you can dig out that document, you'll find that you've got a very good weapon to use against them, because they haven't done anything that's in it, or
which I
they may
speculate,
not have done. And the people we're
yeah,
describing here are probably not showing the passion, because you get these things. I've seen these literally saying we're passionate about helping people with disabilities, and they're taking possession proceedings against them because they can't manage their housing benefit claims. But
yeah,
that's the domestic joint
yeah.
tenancies.